Yes, all are ready? Start. The prescription of a building line on either side or both sides of any street existing or proposed, and the amount of land in such unbuilt area which shall be transferred to the committee for public purposes, including use as public streets by owners of land, either on payments of compensation or otherwise, provided that the total amount so transferred shall not exceed 35% and the amount transferred without payment shall not exceed 75%, of any one owner's land within such unbuilt area. Stop. When a scheme has been drawn up under the provisions of subsection 1, the committee shall give public notice of such scheme and shall at the same time intimate a date not less than 30 days from the date of such notice by which any person may submit to the committee in writing any objection or suggestion with regard to such schemes which he may wish to make. Stop. Next para. The committee shall consider every objection or suggestion with regard to the scheme which may be received by the date intimated under the provisions of subsection 2 and may modify the scheme in consequence of any such objection or suggestion, and shall then forward such scheme as originally drawn up or as modified to the Deputy Commissioner, who may, if he thinks fit, return it to the committee for reconsideration and resubmission by the specified date, and the Deputy Commissioner shall submit the plans as forwarded, or as resubmitted, as the case may be, with his opinion to the state government, who may sanction such scheme or may refuse to sanction it or may return it to the committee for reconsideration and resubmission by a specified date. Stop. Next para. We have no doubt that if the lands were being acquired for a building scheme as contemplated by section 192, the acquisition could not be made under the provisions of the Act unless such a scheme was validly framed after following the prescribed procedure, and was duly sanctioned by the state government. Stop. But it appears to us that the High Court was right in coming to the conclusion that this was not a building scheme under section 192, but merely a development plan to provide facilities to the public, such as those within the contemplation of section 52C of the Act of 1911, to which the municipal fund could be applied. Stop. It was, therefore, not required to follow the procedure under section 192 of the Act of 1911. Stop. Subject to the charges specified in subsection 1 and to such rules as the state government may make with respect to the priority to the given to the several duties of the committee, the municipal fund shall be applicable to the payment in whole or in part, of the charges and expenses incidental to the following matters within the municipality, and with the sanction of the state government outside the municipality. Stop. Over.